Hello, and welcome to this Gowling WLG TUPE Club webinar on how to successfully manage a service provision change. I'm Siobhan Bishop from the Employment, Labour and Equalities team, and I'm joined today by Jane Fielding, a partner in the team, and Louise Clifford, a director in the team, both of whom have extensive experience of advising on all the issues we're looking at today. The presentation will last for about 50 minutes with some time for questions at the end. Now, just before we get started, a few housekeeping points. The webinar has a few simple controls. The most important are the volume adjuster and the full screen option, which are in the bottom of the right-hand corner of your player. There are also some tabs along the top which you can click on to access details of today's speakers, the slides, and some downloads. And you can ask a question at any time. To do that, just click on the Question tab and type in your question and click Submit. We will try and answer as many as we can in the time available. There is also a Poll tab. Don't worry about that too much at the moment. At a couple of points during the webinar, we will flash up a poll automatically on your screen, and we would really encourage you to participate in those, and we will share the results live on air. Now, if for any reason you can't see your current slide, you just need to click on the Slide tab to get back to it. So today, we're covering how to manage a service provision change. And we'll start with Jane Fielding looking at scoping the transfer, and then move on to a middle section looking at mitigating employee risk, firstly on information and consultation, and secondly on contractual protection, which Louise Clifford will cover. And finally, there's a common challenges on exit section, where we'll look at dealing with termination problems. So, if I can hand over to you, Jane.
Thank you, Paul. So, scoping the transfer, why is it important? Well, before you embark on any of the sort of TUPE-related activities, if you think you've got a TUPE transfer, you need to understand the scope of the transfer so you can manage the employee relations risk and also the legal risks in terms of TUPE liabilities and employment liabilities. And you need to work out how you're going to approach that from a contractual perspective, which Louise will look at later. But before we look at the sort of employee relations aspects of managing risk, I just wanted to remind everyone of the effects of TUPE in basic terms. So it's quite draconian left to its own devices. Employees transfer automatically on their same terms and conditions as they had with the outgoing employer. The new employer also inherits claims against the previous employer, any grievances, for example. There are obligations on the transferor in respect of employee liability information and potentially obligations on both parties to consult with employee representatives as well as inform employee representatives. And we're going to look at both ELI and information consultation in more detail, part of managing a transfer successfully. Just finishing off on the effects of TUPE though first, if you're the transferee in particular, you need to be concerned or at least aware of the fact that changing terms of employment becomes more difficult. People affected by the TUPE transfer have increased protection against unfair dismissal. And if you're in a unionised environment, collective agreements with unions and trade union recognition itself may also transfer. So we don't have time to cover that today, but those are things to be aware of if you're in a TUPE scenario. And if you're the customer or the transferee in an outsourcing situation, then you need to be thinking not only about the contractual provisions and the effect of TUPE when you enter into the agreement, but also what the future will look like. What will it look like on exit if you're the transferee, or transferring to a new provider, or bringing it back in-house if you're the customer. And Louise is going to talk in a little bit more detail about that later. So the key really is to be prepared and to bear in mind that an outsourcing situation is not the same as a TUPE scenario in an M&A deal, for example, where you've got one transaction to think about. You've got to think about entry, the life of the arrangement, and exit. And also in terms of differences with M&A, normally in an M&A scenario you'll have a deal room and due diligence will be a structured process. You will get access to hopefully quite a lot of information, but in an outsourcing situation where TUPE is going to transfer the employment liabilities in the same way, you may not have access to that level of information. So you are going to inherit all the employment liabilities as the transferee, with some exceptions around occupational pensions and criminal liabilities, but generally you're going to be wanting to carry out a risk assessment as best you can of what you're likely to inherit. And that will enable you to make decisions about the nasty issues of we've called them, which are up on the screen there. I'm not going to go through the whole list, but those are some of the things we typically see coming up and needing to be investigated and perhaps dealt with in the contract. And as the incoming transferee, you're going to be reliant on the customer, really, to be able to provide you with information so that you can do your risk assessment. And that's because under TUPE, the only thing that you're entitled to as a matter of law is the employee liability information, which is limited. So this is information that goes from the transferor to the transferee. It can go indirectly through the third party, typically the customer, but it's limited both in scope but also in time. So you only get it 28 days before the transfer, and it only has to be accurate 14 days before it's given. So really, in many outsourcing situations, that's quite late, particularly for scope for a bid. But even if you are the preferred bidder, to actually then get your house in order for taking the staff on. It has to be given in writing or a readily accessible format, and it has to be kept updated once given if it changes, right up to the point of the transfer. And in terms of what it is very specific information, and it relates to assigned employees, so those employees who are in scope to transfer, the transferee, but also the second category of staff that we've mentioned on the slide there, who are quite often forgotten in reality, but it's also people who would have been employed and assigned if they hadn't been dismissed under Regulation 7, which is the bit that says if people are dismissed where the sole or principal reason is the transfer. So it's both those sets of people. In terms of the information itself, there's a list there on the screen, which is also available as a download. And you can see from that that it's fairly limited. The starting point is the particulars under Section 1, and then there's some other information around disciplinaries, grievances, claims, etc. In terms of complying with Regulation 11, the duty is not limited to purely contractual terms. So as the starting point is Section 1 of the ERA, that isn't limited to contractual terms. It can be non-contractual discretionary terms. And we've had a recent appeal decision that says, because of that, the transferor, when giving this information, is not required to label the entitlement as contractual or otherwise. That's additional information which isn't needed. And the case in question said that if you do voluntarily give that information, but you don't have to, it's not necessarily a breach of Regulation 11 attracting a penalty. I think in practice, we would still recommend being wary of giving any information you don't actually have to give, because that is not necessarily going to save you in every circumstance. That decision may be quite limited to its facts. So, in terms of ELI, I've said it's very limited. It does not include everything you would want to see. In particular, it doesn't include information about redundancy and severance arrangements. It doesn't include the full range of administrative information you might want to have around, which provider provides benefits that you may need to replicate, who operates the payroll, and it's not going to give you full pension information. So it really does provide a minimum protection for the transferee, particularly in the second generation outsourcing, where it also provides the ability to go directly against the transferor rather than have to perhaps go against the customer under any contractual obligation that the customer's entered into, but it really is a minimum protection. In terms of compensation or financial penalties, this is again specified in TUPE as a minimum of £500 payable by the transferor to the transferee for any breach, unless it's just an equitable to award less. There is, as there often is in employment law, a special circumstances defence, but that is very narrow, and I really wouldn't recommend trying to rely on that. It's there just for completeness, but not to be relied on. So, moving on to assignment. When we're scoping a transfer, one of the key things is to understand who is actually in scope to move across the transferee. And this is important both to the transferor and the transferee and any customer in the middle. for all the reasons set out on the slide there, it's going to be important for both parties to understand workforce planning, particularly if people have got duties split across different activities, some of which may transfer, some of which may not. Where there's a lot of skills or knowledge on the transferor's part, they're going to have to understand how they're going to deal with that. They may need to reallocate people if possible so that they don't lose those skills. And it may be both the transferor and the transferee need to be considering whether they're going to have to make redundancies. So it really is essential for both parties to understand how the workforce assignment works. So when you're looking at assignment, the first question when you're looking at a service provision change is there an organised grouping of employees? And Louise is going to come on to look at that in a little bit more detail at the end. And the organised grouping is something that has to be put in place with a deliberate intent. It's not just happenstance. That's the first question. If you do have an organised grouping of employees, the second question is who is assigned. Now, unhelpfully, as is often the case with TUPE, there is a very limited definition of what assigned is, and all it says is assigned other than on a temporary basis. And what you're looking at is principally the activities carried out immediately before the transfer and who is assigned to those. Ultimately, it's going to be a question of fact for tribunals, and it is one of the most common issues that comes up in TUPE transfer and where there is often dispute, which we have to advise on. So it's a question of fact, and all of those factors on the screen there have to be looked at and considered. The first one, time, I just wanted to flag. We often get asked what's the minimum amount of time somebody has to spend on activities to be in scope of transfer. Well, there is no minimum. It's a factor along with everything else, but it's not determinative. Often people use a rule of thumb of 50% just to kind of get a rough feel for who's in scope, but it will not be the end of the story or determinative, as I say. And in fact, what you probably need to be focusing on more is the grey areas where people are not necessarily devoting all of their time or have sole responsibility for those activities. They may have responsibilities and they may have value to the business spread across different projects. For example, there may be an area manager and a particular activity falls within their area, but their responsibilities are wider. And grey areas can also come up with shared services, central support functions. You can exclude people who are genuinely temporarily with you, like secondees from other employers, and you mustn't forget, conversely, about people who aren't present at the time, perhaps because they're on sick leave or maternity leave, but are nonetheless assigned for TUPE purposes. So in practice, you need to be considering all aspects of the test where there's scope for dispute, applying those factors. And it's necessary to point out that the relevance and weightings of the factors will vary from case to case. So, for example, if you've got junior employees and they don't have sort of split responsibilities, if you like, they work on a fairly vanilla basis, they're probably going to be fairly straightforward to deal with. But where you've got managerial people, some of the other factors such as value to the business, responsibilities at a managerial level, are going to need looking at and perhaps weigh more heavily in the mix.
Thank you, Jane. We're just now going to go to our first poll, which you should be able to see on your screen now. And this is a question, in your experience as a transferee, so that's as the incoming employer, which employment-related issue is the most contentious on commencement? A, who is assigned? B, redundancy costs? C, information and consultation? D, pre-existing liabilities or claims? Or E, something else? So if you can press your responses and we will see what comes out of that result. And they're coming in now, so just a few more seconds. A quick reminder as well that the downloads that Jane's mentioned are available under the download tab. Right, I think we're nearly ready to go. And so there are the results. So that shows that who is assigned is the most contentious issue. By nearly 50% are suggesting that that is the one that they find the most difficult one to deal with. And that probably reflects what we see in practice. Would you say so, Jane?
It's definitely, yeah. As I said, it's one of the most common things that comes up, particularly if you've got a provider who have lost the contract and perhaps they don't have other work to redeploy people onto. If we're advising the transferee, we're often being asked to kind of come up with ideas for pushing back on the number of people that are in scope to transfer, because the transferee is thinking, well, all of those people can't have been doing the activity. Or if they were, perhaps that's why the outgoing transferee couldn't price it properly, because they've had too many people on it. So sometimes you have to come up with very practical solutions for challenging that. Perhaps get the somebody from within the business rather than legal and HR who can sit down with their counterpart and actually sort of run through, well, why do you say this person is assigned, what do they actually do, and try and thrash through it that way. But that does involve a degree of cooperation by the outgoing transferor as well.
Okay, great. Thank you. We're going to move on to the second section now, which is looking at mitigating some employee risks. And Jane will be covering the first issue we're going to concentrate on, which is information and consultation.
Thanks, Yvonne. Yes, so TUPE has an information and consultation regime set out within the regulations, and one of the best ways to mitigate the risk, if you're not going to otherwise have indemnity protection, is to actually conduct the information and consultation process properly. And timing is going to be very key in that, so we're going to look at that in a bit more detail. The next slide just sets out what information has to be given to the representatives by the transferor and the transferee to their respective affected staff, and that is available as a download as well. Obviously, if you're the transferor, you can only pass on information about the transferee's measures if you have received that information from the transferee, and typically the transferor will write to the transferee asking for that information fairly early on in the process. I also just wanted to flag on here the information about use of agency workers. It's the same obligation that appears in collective redundancy consultation as well, where it's a bit more logical to have that, but it also applies here in the TUPE context. It's giving information about how many agency workers the business has, the transferor has, where they are and what they do, and it's anywhere in the transfer or transferee business, respectively, depending on which party you are. It's not just in the part of the activities or the part of the services that are going to be transferring. So it's quite onerous and easily overlooked. In terms of the information duty, it is a distinct duty from the duty to consult, and it's going to apply in every TUPE transfer. There's a qualified exemption if you are a micro business with fewer than 10 staff. It's only qualified mildly though, really, because you still have to give the information. It's just that you can give it to the staff directly rather than to representatives, and only if you haven't actually invited them to elect reps. So it's quite a limited exemption there. In terms of when you give it, again, TUPE is not particularly helpful. It says long enough before the transfer to allow the employer to consult the reps of the affected employees. And just note that this information and in turn the consultation obligations are relating to affected employees, not just those in scope. So if someone at the transferor is going to lose part of their job, but they're not sufficiently in scope to transfer, then they're still affected, and they should be part of this process. Now the timing is going to vary depending on the number of staff involved and the extent of any measures that need to be consulted about. But even if you've got the most basic no measures for a small group of staff, really you're still looking at sort of 14, 21 days as an absolute minimum. So in terms of the separate duty to consult, this is triggered as a mandatory consultation if an employer of affected employees envisages measures in relation to those employees. And again, it's with appropriate representatives. So often when we talk about consultation and we help with consultation processes, what we're actually helping with is the transferor not having any measures of its own for its staff that are in scope to transfer, but it's actually facilitating the transferee coming in to talk to the staff about things it plans to do once it is the employer. So neither has an obligation to consult, but the parties work to cooperate for a smooth transfer. In terms of appropriate representatives then, this is that the primary obligation is to consult with them. If you're in a unionised environment and there's a recognised trade union in place, then they have the primary right to be consulted with by the employer. If there's no union or the union recognition doesn't cover all the staff who are affected, then for the residual group who are not under union recognition, then the employer has a choice. It can either invite the staff to specifically elect reps for this TUPE exercise, or if there's a pre-existing body elected for another purpose which has the remit to be consulted about TUPE, then the employer can choose to consult with them. Now, in our experience, there are pitfalls of going with a pre-elected body, because sometimes the requisite authority might not be there, or it might be overlooked. So often employers will go with a fresh election. So we've just flagged some pitfalls on there to check, depending on whether you're unionised and if you do have a pre-existing body you want to look into. In terms of why it's important to get this right, there is a penalty regime rather than a compensatory regime. So if you do nothing in relation to information and consultation, the tribunal, their starting point will be to award a maximum of 13 weeks gross pay per affected employee. So if you have a finance director or someone in the business who's resisting doing this, a good shorthand is to say, well, the potential penalty is a quarter of the annual wage bill for all the affected staff. That quite quickly mounts up. If you do something, then you can obviously argue down from 13 weeks, and the tribunal makes the award on a just and equitable basis. Again, there is a special circumstances defence, but it's very special, and even in insolvency situations, almost never applies. So again, I wouldn't get too excited about that. And just finally to flag, there is now an opportunity if you're the transferee and you know you're going to be in a collective redundancy situation, so 20 or more people in scope made redundant shortly after the transfer, you can, with the transferor's consent, do pre-transfer collective consultation for redundancy, or at least start it. But you still need to be the employer to actually do the dismissal, so you still can't dismiss until the transfer has actually happened. So just a few practical tips to end on in terms of information consultation. When you're planning the process, you need to factor in time for elections if you are going to invite employees to elect representatives. We would say that takes minimum, unless you've got literally a handful of people, any sizable group is going to take about a week, but it could take longer if you've got people on shift patterns, for example, or a shutdown. And you need to factor in sufficient opportunity in the timetable for voluntary consultation. So even if there is no mandatory consultation because no measures are envisaged, then case law says you've still got to allow an opportunity for reps to ask questions on behalf of their constituents. So again, if you've got a shutdown, that won't be good time. You need to extend the timetable with that in mind, or take a risk that you'll be shortcutting the process. You have to consult with a view to reaching agreement. So that's helpful in the sense of the reps don't have a right to veto the transfer. But you do need to show that you have entered into it in good faith, and we would recommend having a document trail that shows the extent of the information and consultation exercise. So you'll want to have minutes of meetings. Perhaps in a larger scale outsourcing, you'll want to have frequently asked questions, running documents to capture the ebb and flow of the questions and the answers that have been given. And if you can keep something back in terms of showing some movement during the consultation process, then all the better. So I think there's a download in your pack which shows the basic summary of information and consultation. But I'm now going to move on and hand over to Louise, who's going to deal with the contractual ways to mitigate risk.
Thank you, Jen. So, as Jen says, another key part of mitigating risk is what you actually put in your contract. Now, before we look at the specifically at the type of provisions you might expect to see, I just wanted to reflect briefly on the actual structure of an outsourcing transaction and how that might impact on the drafting and negotiation of the contract. Now, set out on the slide is a diagram showing the kind of basic structure you would expect to see in a second or subsequent generation outsourcing situation. And what you can see from that slide is that in the most basic situation, you're going to have effectively three parties in the picture. It might be many more if you've got multiple providers and subcontractors as well. You're also going to have
typically at least 2 contracts which are potentially relevant to the same transfer. But what you can also see from the slide is that TUPE itself operates independently of any contract. So the transfer is actually between the outgoing service provider and the incoming service provider. It's indicated down the slide by the dotted line. Now, in the vast majority of circumstances, there won't be a contract in place between those two parties. So both transferor and transferee are likely to be relying on their contracts with the customer to obtain necessary protection. Now, a number of important points flow from that. The first is that, to a certain extent, parties will be operating within the constraints of the existing contract and what that says about TUPE. So, for example, if you're a customer and you've already agreed to provide certain indemnities in relation to staff who transfer and exit, then that is going to dictate what you may need to back off in your new contract. Conversely, what protections you get from the incumbent service provider in your current contract will potentially dictate what you're prepared to throw down to the new provider. The other point that diagram flags is that it's critical to have regard at the outset of what your exit plans are. So the time for getting necessary indemnities and warranties and so on in relation to exit is at the start of the contract, because you're not likely to get another bite of the cherry. So moving on then to the specifics of what you'd expect to see in the contract. Well, Jane's already talked about the kind of draconian effect of TUPE, particularly with regard to the automatic transfer of liabilities from one provider to the next. And in broad terms, what the parties to a provision change will be looking to do in their contract is to redress those draconian effects of TUPE by making sure that the parties are only going to be liable for that period of time when they actually employ the staff. So the first area that you'd expect to be covered by indemnities are employee emoluments and outgoings, things like tax, NI, salaries, benefits, and so on, and also claims that arise from acts and omissions of the other party transfer, that includes unfair dismissal, discrimination claims, and breach of contract, and so on. And the way apportionment will typically work is that the transferor will pick up all liabilities relating to the pre-transfer period, and the new provider will take on responsibility for employee liabilities going forward, in fact, the period going forward. Now, you do need to watch out for certain liabilities that may not have crystallised by the time of the transfer. So holiday pay is a good example. So what you have with holiday pay is employees accruing rights to leave in respect to the period of the transfer, and they may have taken more or less than they're actually entitled. Now, the actual cost of that holiday entitlement is not necessarily crystallised until some point later. So often you'll get provision for a balancing payment to be made either to or by the transferee, depending on whether the employees transferred have taken more or less than holiday than they've actually accrued by the point of the transfer. Bonus and commission is another area where you might see specific apportionment provisions, particularly if, for example, you've got a new provider taking over staff partway through a bonus year. In those circumstances, they're likely to want some kind of provisions that whereby they can recover part of that payment from the transferor or by the customer. The next area where you might expect to see specific provisions is in relation to specific claims that aren't necessarily covered by the pre-transfer act and omissions indemnity. Now, these are the exception rather than the rule. You don't always see this type of provision. But a good example of where you might need one of these provisions is where there's, for example, a known equal pay liability. In that situation, you could have a transferee inheriting an existing claim, but also accruing further liability in relation to that equal pay issue from the start of the new contract. And in that situation, they may want to a more broader indemnity than is provided by the pre-transfer act and omissions indemnity. The third area you'd expect to see covered is in relation to information and consultation, which Jane talked about. And here it's usual to have a fairly straightforward straightforward reciprocal indemnities between the parties in relation to each of the failures, if any, under the obligations under TUPE. You might also see more general provisions whereby the parties effectively agree to cooperate in terms of those information consultation obligations. Now, those three areas you would expect to see covered in a very similar way, both on commencement and on exit from the contract. What you also need to consider, both as a service provider and a customer, is what extra protection you need in relation to the lifetime of the contract. First of all, if you're a service provider, you need to think about whether there could be additional TUPE transfers after the initial transfer of staff on day one. And that could arise, for example, where the customer retains the ability to add in extra services during the life of the contract. Now, if there's a chance that those additional services can trigger another service provision change, then the service provider will want to ensure that they are protected against inheriting further employee liabilities. Looking at it from the customer's point of view, the customer is likely to want robust exit provisions relating to employee information. The ELI provisions that Jane talked about, which kick in 28 days before the transfer, should be very much seen as a basic backstop, if you like. In most cases, the customer will need access to more information and at an earlier point in the process. So, particularly if there's going to be some kind of formal retendering process on exit, the customer is likely to need employee information several months before the end of the contract in order to be able to share that with future potential providers and bidders. The other thing the customer is going to want to be covered are what we refer to as workforce status quo provisions. You may have seen these. These are kind of standard restrictions that you see kicking in once notice has been served or a certain number of months before exit. And what we mean by this is that there are restrictions that stop the service provider making key changes to the body of employees who may ultimately transfer across. So it's things like restrictions on changes in terms of conditions, adding in extra staff that haven't previously been on the contract, removing key staff that might be fundamental to the service so far. And the reason for having these types of provisions is effectively twofold. First of all, to avoid the new provider inheriting this poisoned pill and lots of additional costs from changes having been made at the last minute. And it's also to help ensure that there isn't a watering down of the skills and knowledge that are going to be needed by the new provider in order to be able to deliver the services following exit. So just a couple of general points on the contract. The first is that you need to remember that what you put in the contract, particularly around TUPE, will often have a direct impact on what is happening on the ground. So it's not a case of doing these contracts and then putting them away and withdraw. There needs to be early cooperation between the legal and commercial teams and the HR team, and you'll need to refer back to the contract at later points, particularly on exit, to see what obligations you might have agreed to. Just give a simple example: if you're a commercial party, if you're a provider negotiating provisions about employee information and when that's going to be provided, there's no point agreeing to do that within 7 days if HR is going to need 21 days to collect and deliver that information. So there needs to be a dialogue with the relevant people who are going to be operating the contract from the start. The other point about outsourcing agreements, and particularly the TUPE clauses, is that unusually you're actually looking to extend the protections to cover third parties in a lot of cases. So if you are a service provider, you'll be looking to ensure that if you're planning to slow down protections for subcontractors, then they are covered. Similarly, if you're a customer, you want to make sure that when you come to retender services in the future, any new providers are protected in relation to the same CP issues. Now, the simplest way to achieve this in practice is often to just make sure that the indemnities are expressly made in favour of all the parties who need to benefit from them. But what you must remember if you do that is to make sure that third-party rights, the right to enforce those indemnities directly, aren't excluded in some other parts of the contract. So just some practical tips on mitigating risk before we leave this section. First of all, make sure you understand the structure at the start, understand what contracts are in play, and also understand what events may trigger a CP transfer. Remember to dust off that existing contract and work out what existing commitments may already cover the service provision change in question. And going forward, make sure you have robust contractual protection to protect you both at the start and end of the contract and during the life. Finally, start early. James talked a lot about planning. CP itself is quite light in terms of specific deadlines, but certainly the earlier you start the planning process, the smoother the process is going to be, and the better the outcome for all parties.
Thank you, Louise. And as Louise mentioned, we're now moving to the last section today, which is looking at some of the common challenges faced on exit, and I'm looking at the risks and solutions there. So back to Louise.
Thank you, Siobhan. Yeah, so the focus of today has been predominantly on what you do when you've got a service provision change, when it's known and understood that staff will be transferring on commencement. But what happens if things aren't so straightforward when you get to exit? In particular, when might you encounter specific arguments that CP doesn't apply? Now again, before we look at the specifics, there are just a few general points I want to start with. First of all, you always need to consider the potential application of CP on exit, even if you don't think it will apply. In my experience, where CP applies at the start, the parties will naturally be thinking about how it's going to impact on exit. Where it is sometimes missed, however, is where the parties might be entering into a contract for brand new service, where staff aren't transferring to the service provider on day one, and parties may not anticipate how the services can evolve over the life of the contract and how a dedicated workforce can build up. So always consider it, even if you think the application is unlikely. And actually go one step beyond that. It's safest in all cases to assume that CP will apply. It will apply in the vast majority of outsourcing situations where you've got a dedicated body of staff. Even if it doesn't apply, by making the assumption that it will, you can make sure that you've got the appropriate protections in your contract and make sure that all parties are protected at the end of the contract. Finally, do of course watch out for some of the more complex situations which we're going to come on to talk about. Now, I should just say before we move on to the challenges themselves, all of these challenges relate specifically to the service provision test. As Jane's already mentioned, there are two tests where people can apply, the other being the kind of classic business transfer test that you encounter in M&A transactions. So what you need to remember is, if any of these arguments succeed and CP and the FTC test doesn't apply, you still need to remember to go back and check whether the transfer could actually amount to a business transfer. So the first common challenge I'm going to look at is where activities change or where they're alleged to change. For the FTC test to apply, the services provided by the transferor have to be fundamentally the same as those provided by the transferee. Now, as you expect with CP, there's no clear test or guidance to set out how exactly you go about working out whether services are fundamentally the same. But there are some kind of pointers that we can take from the case law. The first is that you need to apply some ordinary common sense approach to the meaning of fundamentally the same. So you should disregard any minor differences in the way services are delivered or in what services entail. What we also know is that there can actually be more than one transferee. It's not necessary that all of the activities provided by the original provider are then replicated by a single new provider. Ultimately, though, it's going to be a question of fact and degree as to whether the services have changed fundamentally or not. And that's going to require a detailed analysis based on the particular facts. Some practical tips, though, if you are faced with this situation. As a starting point, you need to look at the contractual description of activities in both the old and the new contract. And that might give you some kind of flavour as to what the nature of any changes are. But the analysis shouldn't stop there. what we also know from the case law is that you have to focus on what was actually being done before and after the transfer on the ground. So, for example, TUPE has been held to apply in a situation where both the transferor and transferee are operating under framework agreements that give them neither a guarantee of any work or indeed any obligation to perform any activities. And TUPE held to apply actually on an analysis of what was happening on the ground. The activities that were being carried out were held to be fundamentally the same. You should also look at the fact that you can have a split along functional lines. We've had this confirmed recently by case law, and essentially it's now clear that in the same way as you can have transfer of part of a business in an M&A type transaction, you can have a transfer of part of activities. The second potential area for challenge is fragmentation, which is actually closely related to the first point. And what we mean by fragmentation is essentially where activities are split between multiple providers. Now, as we've already seen from the previous slide, it's not every case of fragmentation which will defeat the application of TUPE. We've already seen that you can have service provision change where services are split along functional lines. Equally, where services are split along quantitative lines, for example, where one service provider is replaced by two new service providers and one of those takes over the greater part of the activities, then again, TUPE can still apply. So the key question you have to ask yourself is whether there's what the case refers to as a discernible pattern of reallocation or transfer. And what that essentially means is there any way of actually tracking through where particular activities have ended up? If there isn't, then the FTC test must be met. The third area for challenge, and in my experience is one of the most common issues you face in practice, is whether or not there's an organised grouping of employees. Now, for the test to be met, the organised grouping must have as its principal purpose providing the relevant activities on behalf of the client. So, although a grouping can actually refer to a single employee, if that single employee or grouping delivers services to a number of different clients and gives them equal priority, you can say it would be difficult to make out the argument that the activities of one client form the principal purpose of that grouping. But there's another difficulty that's been brought about by the case law, and that's the fact that an accidental grouping of employees isn't enough. You have to demonstrate there's been some deliberate planning or intent in putting together a group of employees for the purposes of the activities. So what you're really looking for is some evidence that the employee's been organised by reference to a specific contract or client. The next point I want to look at is where you've got a change of client. Now, this issue first arose actually in a property management context, where there was a change of property manager in relation to the property at the same time as a sale of the building that was being managed. And what the court said in that particular case was that for the service provision change to be met, you have to have the same client both before and after the transfer. Now, it's not often going to crop up, but it has been suggested that the same kind of principle could apply in relation to subcontractors. So the suggestion is that if you have a change of subcontractor at the same time as a change of prime contractor, then you might not be able to point to a common client. Now, in reality, I don't think that's going to occur in many cases, because in most situations it will be relatively clear, or at least in my experience, that subcontractors are providing activities on behalf of the ultimate customer. But depending on the nature of the relationship between a subcontractor and a prime contractor, that is potentially an argument that is open to the parties. So finally, on potential challenges, I just wanted to mention very briefly the exceptions under TUPE. These are set out in the regulations themselves. I'm not going to cover these in any great detail because they don't crop up very often. TUPE specifically doesn't apply where the contract is solely for the supply of goods for client's use, and neither does it apply in connection with a single specific event or task of short-term duration. There's quite a body of case law which we don't have time to cover today in relation to both of those points, but if you do think that either of those potentially applies, then you should take further advice on that. So just to summarise where we've got to in terms of managing challenges, first of all, consider the impact of how these challenges should impact on the way you actually manage your workforce. So, for example, if you're a provider and you want people to apply at the end of your contract, make sure, for example, that you have a clear, organised grouping of employees delivering the services. Also consider future-proofing. So think about the ways in which a customer might look to re-tender in the future. Is there a chance, for example, that services might be subdivided into smaller lots? Is that likely to be along quantity or quality lines? And think then about how that might impact on how you manage the workforce in the meantime. And finally, if you're concerned about the potential for people not to apply an exit, then you also have the option to seek a redundancy cost indemnity. Of course, whether or not that can be obtained will depend on the particular commercial realities of the transaction in question.
Thank you very much, Louise. That brings us on to the final poll, after which there will be a chance for questions. So there is still time for you to submit a question under the question tab. But in the meantime, we have the poll, so please participate in that. And we're asking, in your experience as a transferor, so that's as the outgoing employer, which of these is the biggest problem on termination? A, whether TUPE applies. B, workforce planning and who is assigned. C, information and consultation process. D, risk of claims. Or E, something else. So I'll just give you a few moments to go to the tab there to vote for your experience and let us know how you find this works on the ground. On the questions, we've had a few coming in, particularly relating to assignment, which reflects the answer to the first poll, which said that assignment was one of the most common issues for difficulties on commencement. So it'll be interesting to see how we fare in relation to assignment on exit as well. Okay, just a couple more seconds and we're ready to push those poll results out now. So, on termination, the biggest issue is whether TUPE applies, which again reflects what we see particularly in the case law, which has challenged almost every aspect of the definition of a service provision change in minute detail.
Yeah, I'm not surprised by that outcome, and I think when the service provision change test was originally introduced, the idea was that it would provide some certainty to parties, because prior to its introduction, the parties were trying to shoehorn outsourcing situations into the business transfer test. So whilst it did provide an initial element of certainty, the actual growing body of case law over recent years, I think, that led to more potential challenges than we ever thought possible. The fact that we don't give a purposive interpretation to the words in the service provision change because it's not based on EU law, I think also impacts on the level of certainty, because I think under the old rules you could always guarantee that once you apply the kind of purposive interpretation, what might be a kind of 50-50 case would tip over into being a TUPE transfer, but we don't have that now, so that doesn't surprise me.
So just to confirm, that was 32% of you saying that whether TUPE applied was the biggest problem on termination. But it was quite closely followed by who is assigned at 28%. So we'll turn now to some of the questions that have come in. And as I mentioned, there have been quite a few on assignment. So the first one, Jane, will go to you to ask you, relating to staff on long-term sick leave, how do you decide if they are assigned?
Okay, well, just because someone's on long-term sick leave doesn't rule them automatically out of being assigned or in. It is part of the factual scenario, which, as I mentioned earlier, you have to look at all the relevant facts. There has been case law fairly recently, although the litigation did settle before we got a further appeal decision in it, about a person who was on PHI.